Kanpur, my lord. How this honorable court can grant any relief?
From Kanpur?
Kanpur, my lord.
Okay. Yes.
But the matter comes on tomorrow. I think bench is not available. Tuesday, my lord. I'll have
Come on
instruction.
Tuesday? Yes. Yes, heard Mr. K. Paul Senior Counsel, assisted by Mr. S. Kiriam. Issue notice. Dr. N. Mozikani JCI is present. Assisted by MS Chang present. As such, no further notice. What about number 4? You'll accept for number 4 also?
Commission GST through
You can take only 1, 2, and 3.
1, 2, 3, and 5 also.
Huh?
1, 2, 3, and 5. Department.
5 is Uttar Pradesh.
Yes, 1, 2, 3.
Yes, then we have 1, 2, and 3. So for no further notice required on these respondents. Steps will be taken for issue notice to remain calm within 2 days. Stop. Yes.
My lord, at this stage, because we are raising the territorial jurisdiction.
Yes, that's what.
My lord, let it come only for instructions, my lord.
Yes,
without notice today, my lord.
Yes, without the issuance of notice. Okay, let us issue, yes.
What will happen otherwise? Notice it will remain on service of notice only. I'll have instructions on Tuesday, whether this petition is maintainable.
Okay, next paragraph also. As Dr. N. Mozika has raised an issue with regard to the jurisdiction, with regard to their jurisdiction, as vis-a-vis the cause of action. Let this matter appear on Tuesday for motion. Yes, on Tuesday. Yes, urgent hearing on Tuesday. Yes, Tuesday that is the 14th, please.
Well, steps is not required at this stage, my lord. If it is not maintainable, my lord, issuing notice to Kanpur authorities.
See, once we find that the territorial jurisdiction is there, then we won't even need. Can pass any orders will be effective.
Yes.
Because here, you see, you're maintaining that the writ will be maintainable here. So if the maintainable here, then Dr. Mozika will be the correct counsel to represent GSC authorities. Even or any orders passed, then it won't be implemented by the authorities there. Yeah, let them serve by dusty possible also. Yes. Right. Yes, next.
Daily list, item number 1.
Please, Your Lordship. Lordship, as per the last order, today is fixed for the appearance of the private parties in Lordship.
You're appearing for 7 and 9.
Lord, I have instructions to appear for the private respondent who was the petitioner, my lord. Of course, I do not have a copy of it.
7 and 9.
7 and 9, Lordship.
I'm entering appearance on behalf of 9.
What about 7 then? They've been served?
Lordship. We have filed our service affidavit also.
Committee. Yes, the petition. You are appearing for number 9. But this is.
I was the petitioner, my lord, in the writ petition.
But the petitioner is Jasmine, the appellant is Jasmine Zahir only.
Yes, Your Lordship. I was the
in
petitioner in the writ
WPC,
petition.
respondent number 9 was the petitioner. In WPC number 114. This is the writ appeal. This is writ appeal.
shown as
Lordship, I will have to put
appeal,
the
Jasmine
next
Zahir is the
page.
My lord, the
petitioner.
appeal is filed by the private
Sultana
respondent.
Sarkar.
No, Your Lordship.
Who is the
Lord,
appellant?
appeal is filed by the private respondent.
Private
In
respondent.
the
Okay,
writ
okay.
petition.
Lordship, at page A.
Right, okay, got it. Sorry. Sonia Sultana was a writ petitioner.
Yes,
Lordship,
You are
yes.
appearing for, right? Yes, Mr. KP Bhattacharya is entered appearance today on behalf of spot number 9. However, in spite of service of notice, there is still no appearance on behalf of spot number 8. Yes, what do you want?
Not
copy of the appeal be made over to the to Mr. K.B. Bhattacharya. Yes. Yes, for today for what?
It's fixed for admission hearing, but
not admission hearing, my lord. It's fixed for admission.
Fixed for admission, yes. So this is the matter of 2 weeks for admission.
Admission.
Lordship.
Offline.
If they are here or not, we'll hear it.
Item number 2.
I don't remember. I looked at the wrong course item.
But 2 and 3 you are filing affidavit today, my lord, in the course of the
Yes. 2 and 3.
You are filing affidavit today, my lord.
Yes, Dr. N. Mozikal GI submits that after we find the course of the day.
2 and 3 both.
Yes. For rejoinder when?
Up to 3 weeks.
Yes, after 3 for rejoinder, if any.
Yes. Much
Item number 4.
It's for rejoinder, my lord. We have filed affidavit only.
You file rejoinder? No, we'll close it, Mr. Paul. This is last time was that next year rejoinder should be on board. How many times you have taken rejoinder?
Lordship, we are filing in the course of the day. Advance
the
copy
day?
has already been served, Your Lordship.
Okay. So you have not instructed properly, Mr. Paul.
My lord,
Mr. Mr. Kiriam says that it's being filed. Yes. Yes, Mr. S. Kiriam.
Obliged.
Submit that rejoinder will find the course of the day. This is the matter of hearing after 3 weeks. Yes.
4 and 5.
4 and 5.
4 and 5 both, my lord.
Item number 6.
Well, 6 is required to take obtain some instructions, but the instructions haven't come. The officer
This is
has been,
regarding the miss case.
yes, madam.
What's this miss case 43?
Last one.
It's for
So stay on the recovery of the balance amount.
oh. So we'll
But instead of going into miscase matter, otherwise the main case is ready for hearing. My lord. They are yet to file the rejoinder, my lord, and the matter can be heard.
no, we have to take out the miss case or because they are asking for stay of the penalty. So who's leading you in the case? Mr. Sahu.
Sahu.
Where is he today?
He is out of East Western. He is Kolkata today.
Okay, Dr. N. Mozika prays for allowed for the 2 weeks time to file objections to the witness application. Stop this after 2 weeks together with the main petition. Yes, for further orders.
Item number 7.
Oh, yeah, I'm praying for some time, my lord, for affidavit.
This is income tax matter.
Lordship, interim
The GST
may
matter.
continue.
For GST, yes, sir. Yes, sir. Dr. N. Mozika prays for the 2 weeks time to file affidavit. 2 or 3 weeks.
3 weeks.
3 weeks time for affidavits. List accordingly on so and so. Interim order of any shall continue. Shall continue to the next date. Yes.
Item number 8.
Meet please. Lordship, the notice of the income tax
Please, Your
department.
Lordship, before learned EG starts, Lordship, I'm appearing on behalf of Mr. SCKL. I'm praying for time to file the affidavit, Lordship.
Yes, to M. Merchant, Vice Mr. SKL, has another appearance from Ms. M. Merchant and Mr. SKL, Vice Mr. SKL, the appearance on behalf of the respondent. She prays for allowed how much time?
3 weeks time,
To
Lordship.
file affidavit is.
Only issue, Milord, is that there is a miss case, and in the state government is not covered under Income Tax Act, Milord. That
We are aware of that. Yes, the prayer for the
To file
prayer
an
for interim
affidavit,
stay shall be taken up on the next date. Yes.
Lordship.
There is a care to come.
yes, ma'am.
Item number 9.
Yes. Yes. MS Pradhan.
Lordship, I'm appearing on behalf of respondent 2 to 6, Lordship. The matter is still pending before the Apex Court, Lordship.
Yes, as the matter is still pending consideration for the Supreme Court list after 6 weeks. Yes. Madam.
Highly obliged, Lordship.
Are we having Any mention?
May I please, Your Lordship? I beg to mention item number 25.
25.
Yes, Your Lordship. The learned senior counsel is in bereavement, Lordship.
Yes, okay.
So may this matter become up after 3 weeks, Your Lordship.
Yes.
No objection, Your Lordship.
Much obliged.
Yeah, they also.
Yes, Your Lordship.
Yes, Mr. Sam.
Respondent number 3 and 4.
For respondent one and two.
Where we can join request, Your Lordship, with a private respondent. Item number 27, my lord. 27.
Review.
Yes, Your Lordship.
Why joint request?
Having some difficult financial difficulties. My lord.
No objection.
No, Your Lordship.
Okay, after 2 weeks.
Most blessed, Lordship.
Your Lordship, I beg to mention item number 35, Your Lordship. And for respondent number 6 and 7, Your Lordship.
Who's for the petitioner? S.K. Hassan. When was Hassan? M. Rehman. Any objection? 35. Inform them before, if you take adjournment, inform the other opposite counsel, please.
Lordship, here I'll pray to file my rejoinder.
You haven't filed rejoinder as yet? Why?
Lordship, this is the first time it is come for hearing.
First time.
Lordship.
Okay. 35.
35.
Yes, after 2 weeks, rejoinder we file the meanwhile. Yes.
Lordship. Obligation.
Oblige, Your Lordship.
What is this after 2 weeks? Yes, Mr. Todi.
To mention item number 28 of today's list, Lordship. With consent of the other side, may I pray the matter may be taken up in the 3rd week of May, Lordship, subject to Lordship's convenience.
Why 3rd week of May? Now we only in the 1st week of April or 2nd week of April, yes. Who's the other side?
I'm there, my lord.
You're with
petitioner.
Dr. Todi?
For the petitioner.
You have no objection?
My lord, I also have to cast my vote today, my lord. So
Today also you go then, cast your vote. After 3 weeks, yes.
Yes.
3 weeks, yes.
Much obliged.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 34.
Yes.
Your Lordship, I humbly pray to kindly this matter be presented. Yes, Your Lordship.
What's the matter about?
No objection, my lord.
What's the matter about?
Your Lordship, it's like a government service, the degradation of this post.
You have no idea, okay. 2 weeks, yes. Yes.
Hello, please, Your Lordship.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item 29, Your Lordship. We have filed rejoinder yesterday only.
So that means you're ready for the hearing? Yes.
No objection, Your Lordship.
1 week, 2 weeks?
2 weeks, Your Lordship.
2 weeks. Apply, Your Lordship.
Highly obliged.
My lord, I beg to mention item number 36, 37, 38, 39, my lord. These are connected matter, my lord. Mr. Hassan is here for the petitioners.
Lordship, in this matter is
Oh, agency.
we're supposed to take some instruction regarding the percentage of the gratuity matter.
Who's supposed to instruction?
SK Hassan, he's appearing. He's on his leg in courtroom number
My
1.
lord,
Kindly
this
call
is
up the
with
matter,
regard
my
to
lord.
my DCRG. We have already filed an affidavit bringing into record that they have been released. Mr. Hassan on the last occasion has made a
Let him
submission
bring
that
instruction.
regarding interest, my lord. So we don't have any instruction with regard to the interest, my lord.
Lordship, let's the matter call up.
Let me have a report of this. You can dispose of it. Yes.
Meet, please, Your Lordship. Lordship, item 24, Your Lordship.
What about item 24?
Lordship, I'm seeking accommodation, Your Lordship.
No, who's other side?
Miss S. Bhattaji, Your Lordship, she's in sanction leave.
Now she's not been coming to court for how many months now?
But she's not detected on sanction leave.
But even then, but the matters is H. Abraham, Zain Inong Country, S. Barachaji, S. N. Gupta, S. N.
My lord, Ms.
They've all been
Mrs.
out for the panel
Bhattachaji
now.
has actually requested some of her close colleagues to take up her matters. So this particular matter, my lord, I'm not aware to whom she has actually given the file. So, my lord, she
So
must have...
there's no coordination in your,
No, my lord,
in your government office.
Mrs. Bhattachaji has her own close colleagues, my lord, to whom she hand over the files. So, my lord, I'm not particularly aware to whom she has actually requested for this particular matter, my lord.
So when the lawyer is available, the file doesn't go back to senior government advocate for the allegation, for for reassignment? No.
No, my lord, it depends on the council, my lord, if they have surrendered, my lord, like Mr. Momin's case, my lord, he has surrendered all his files and has been re-endorsed. So Mrs. Bhattacharjee has not
After
done
1
the same,
week,
my
you
lord.
make arrangements. Yes.
My lord.
Lordship, similar pay for item 26, Your Lordship.
Number?
26, Your Lordship.
What is it? Where's Dr. Mozika? Yes, where's Dr. Mozika? It's regarding that. It is hit by delay, right?
Yes, Your Lordship.
Continuing cause of action is there, Your Lordship.
So you know that part. This continuing cause of action. Why is so one time today?
Required physical hearing, Your Lordship.
You are here physically.
My senior is leading in this matter, Your Lordship.
Where Dr. Mozika is on legs?
He's currently on legs, Your Lordship.
1 week, yes. He prepares.
Highly obliged, Your Lordship.
Otherwise.
From supplementary list, item number 1.
Yes. Yes, Tazarika.
May I please, Your Lordship, that is regarding the we have opened our account in the HDFC Bank in Mendipatar, my lord. That our account was freeze on the basis of a letter sent by one SI Narendra Singh, my lord. It is in page number 15. They are writing in Hindi. Next is translate copy of English, my lord.
You have not made any local authority party?
Party is because local authority is a bank only, my lord. Mendipatar, HDFC Bank.
How is state of Haryana? What for? What good you mean?
No, because of this police, my lord, coming in the page
Police,
number.
I can understand. So police, Gurgaon, whatever.
Oh yes, my lord. Police to ultimately
Page, what page?
Page number 15, my lord, and
You have to recast
translate
a
copy
petition.
on 16. Shall I read out, my lord?
No need to read out. Complaints also accounts to provide bank statement. You have to make the local police also party. How will they coordinate with the police there?
We will send
You
notice, my
make
lord.
parties first. Mr. A. Sarika prays for and is allowed to implicate additional parties by application. Yes. Yes, after
Item
1
number
week.
2.
I'm helping you, Mr. Sarika, because too many these freezing cases. You have not made even the local police party. Yes. Yes, Mr. Sheikh.
Yes, may it please your lordship. Lordship, here the
What is it?
petitioner was appointed as an assistant laboratory science assistant, lordship. Science
Assistant?
laboratory science in the year 2015. Then subsequently his appointment was approved by lord. That is at page 13, lordship. Now, my lord, there is a disparity among the laboratory assistants working in 3 different categories of school, lordship. That is government higher secondary school, deficit higher secondary school, and ad hoc higher secondary school, lordship. My lord,
Just please repeat that. What are you saying?
this is a assistant laboratory
There's
science.
there's differences between whom and
Disparity between the persons working as an assistant laboratory science in 3 different categories of school. That is, one is government higher secondary school, then deficit higher secondary school, and ad hoc higher secondary school. My lord will come to page 14, lordship.
Yes.
14, lordship. This is a letter issued by the director to the government, lordship, under secretary. Submission of suggestion and comments for the draft policy of education department. Now I'll just read out the content of the page 14. In continuation to this office on the subject referred to above, I am to inform you that the science stream of the following category of school, the numbers of sanctioned posts are indicated as follows, lordship. Government higher secondary school, 6 assistant lecturer and 6 post left assistant. Deficit higher secondary school, 6 post assistant lecturer, and some deficit have only 2 left assistant while some have 3. Now I am on 3, lordship. Ad hoc higher secondary school, 6 assistant lecturers, lump sum grant without any post of lab assistant. Although lecturer posts were sanctioned, but the lab assistants posts were not sanctioned, Lordship. On the
And
above
you're working in ad hoc school.
ad hoc, Lordship, yes.
And you've appointed library assistant.
Yes, yes, yes.
There's no post library assistant. How you appointed?
That there is no, my lord. That is why, my lord. Although chemistry, physics, and biology.
No, that's well and good. But you appointed regularly against a vacancy. Appointed against a vacant post.
Because in all such school, Lordship, because without that laboratory science assistant.
How is it continuing then? So from this lump sum grant.
Yes, from the managing committee, Lordship. Because without the lab assistant, they cannot function, Lordship.
Take notice. You heard Mr. Associate, the council petitioner. Issue notice. MSK Yangi B. Then AAG with Mr. A.R. Khan present on behalf of all the respondents. No further notice required. Just after 3 weeks for instructions or affidavits.
Daily list item number 1.
I'm praying if your lordships kindly have it next week sometime, please.
Last week you were the same prayer to be present physically. Where's the respondent? Who's for the respondent? Who's for the respondent? Who's for the respondent?
Lordship, Mr. S. Lordship S. Arlinda.
Lordship, kindly adjourn this matter. Actually, the conducting counsel is in this post. Medical treatment, Lordship, is going on. So give actually 1 week, Lordship.
Okay, the prayer soon, sir. This matter after 2 weeks.
Much obliged.
Give him enough time to recover.
Item number 2.
Your Lordship, I'm appearing on behalf of the petitioners.
Yes.
Your Lordship, we are seeking 3 weeks time to file the rejoinder to the affidavit and oppositions on behalf of the respondent numbers 5 to 16.
You all file affidavits?
Yes, Your Lordship. All three of them have filed the affidavits, and we have to file the rejoinder.
You are Mr. Khemka?
Yes, Your Lordship, Mr. Khemka.
Mr. Khemka, learned counsel for the petitioner. It is for about 2 weeks.
Your Lordship, I'm just beseeching Your Lordship to kindly fix it on the month of May, 14th of
That
May.
you'll have to ask the local council. Yes, just after 3 weeks for rejoinder. We give 3 weeks only. We don't give more than that.
Your Lordship, Mr. Mukherjee will have to fly down from Calcutta for this.
Doesn't matter. Yeah, 3 weeks. Make arrangements. Yes. As per.
Your Lordship, he is not available. He's in some personal difficulty, Your Lordship. I'm beseeching Your Lordship.
Then you take a deal in the court, Master. Yes. Yes, on so.
Yes, Your Lordship. Grateful, Your Lordship.
Item number 3.
Please, my lords. This is that matter concerning those tainted teachers, my lords, and we were here before your lordships in connection with, my lords, post the setting aside of the criminal proceedings for reconsideration of the matter. Now, my lords, I am informed a similar matter had come up before my lords yesterday, my lords. This is WPC number 146 of 2026.
Yes, Lordship.
Same order,
same, my lord. Same.
My lords have issued notice on the matter and fixed the matter on 24/4/2026 for instructions. My lords, I think all these matters can come up together. The 3 matters.
May it please your Lordship. Lordship, there is another petition, that is WPC number 112 of 2026. This is coming on 15 April, your Lordship, and WPC number 122 of 2026 coming on 14.
No, but this one's not a different footing. Mr. Paul last time said it's a different footing.
Lordship, so far this matter also.
You were there last time.
The same, Lordship. Lordship, so far this matter, your Lordship, let it come together, your Lordship, on 24, your Lordship. Only the question of locus and maintainability may be kept open, your Lordship.
Yes, Mr. K. Paul and counsel submits that as the identical matter is to be listed on 24th. He prays that the incident matter be listed together. So CM not objected to Mr. N.D. Schweiler AG just on 24th.
24th, your Lordship.
Yes.
Other matters also, as and when they come up, we'll make a
yes,
mention
we'll
so
make
that
it to you.
your lordships can hear all the matters together.
Yes.
Lord.
Item number 4.
Please, Lordship, here I am seeking time to file my rejoinder, Lordship, because they have filed another additional affidavit. So therefore,
you filed it. You have not filed agenda as yet?
Not yet. We'll be filing your Lordship together because.
Okay, yes, as prayed further, 2 weeks time for rejoinder.
Lordship. Much blessed.
Item number 5.
Well, in these two matters, 5 and 6, my lord, I would like to file a small affidavit. I would like to file an affidavit, my lord. This is a contempt matter. I would like to file an affidavit.
Yes, Mr. As a brief for allowed, how much time?
2 weeks will do.
2 weeks time to file affidavit, yes. Yes,
hello.
Item number 7.
Where's Mr. Chanda?
He's having some personal difficulties, Lordship.
Well, AG is here, no?
Lordship, he's coming on next, my lord, before Kuru number 1.
After some time? End of the board?
Next week, your Lordship, subject to your Lordship convenience.
This matter is to be closed, I think.
Lordship, as per the prayer is infructuous, my lord.
Yes. Has it been tendered for the other materials have not been supplied? You have any instructions?
No, my lord. Lordship, next week, your Lordship. Lordship, my senior is online.
Is there? It becomes very difficult, this virtual call. Yes. What instructions we have out here, Mr. Paul?
Matter, my lords, I had informed your lordships on the last occasion as well, my lords, that we want to take up this matter. It's just that, my lords, I want that I should be physically present to, my lords, argue this matter. Next week, my lords, any date convenient to your lords.
After 1 week.
Because they have, my lords, issued the work order nonetheless, but, my lords, as we had argued on day 1, that it is customized for the private respondent. So
yeah, but now it's already work order has been issued, and there are many items that have been what to say has been retendered as per instruction. Correct?
Lordship.
You have no idea.
Lordship, I don't have the instructions.
It's not, my lords, it's not retendered. That certain items, the first tender has been given to the private respondent. That much I am aware of.
Next time. Yes.
Right.
8.
May I please, your lordship? My lord, this pertains to the clerical trade. My lord, division bench had, my lord, upheld the pay parity. The SLP against that, my lord, was dismissed. Our review has been filed, my lord, but then last 2 months, my lord, it has not been listed.
I have the same instructions.
What instructions you have? That's
Lordship.
Today, where's Dr. Mizika?
He's currently on legs, Lordship. But Lordship, I have the same instructions, Lordship. Review has been filed, but it has not been listed yet. So if your Lordship would kindly list this.
You know the review in Supreme Court not even taken inside court. They are in chamber.
Lordship, I'm
Then
aware.
also need for compliance.
Case 184 otherwise is, my lord, the order.
Yes.
Of the division bench, my lord.
Lordship, I'm praying if your Lordship would.
There will be nothing for this court to do here. Because it gone on appeal, it's been dismissed, gone to SLP. We have this court hands are tied. There's no question of arguing it here or there, that's all. You tell him, Dr. Mozika.
Lordship.
As Dr. Mozika is not present, just after 1 week to enable the respondents to obtain instructions.
Item number 9.
Oblige, my lord.
If Lordship, this second time I was praying for filing my small rejoinder, Lordship. This is regarding the, yes.
Regarding?
Regarding the payment of some gratuity, Lordship.
For the 2 weeks has paid allowed for.
Much blessed, Lordship.
Item number 10.
Lordship, the state has filed their affidavit this morning.
My lord, here I am praying for I am appearing for respondent number 4, Lordship. I pray for further 2 weeks time, Lordship. I'm waiting for the signature, Lordship, because she is from Mughar, Lordship.
5 and
Within
6?
2 weeks, I'll file it, Lordship.
Even for your lordship. Respondent number 4 haven't filed your lordship.
That's why I am praying for time.
Yes, Ms. T. Yangi B. AG submits that the affidavit on behalf of respondents 1 to 3 since been filed. Stop. Ms. S.E. Sheikh for respondent number 4 and Ms. Rahman for 5 and 6. I will pray for further 2 weeks time to file the affidavit. Praise allowed this after 2 weeks.
Much obliged, your lordship. 11.
Salary.
My lord, the states have filed an affidavit, my lord. They have brought some factual aspects also, my lord, which we are not aware. We need some time to take instructions, my lord.
What's the matter about?
My lord, this is dismissal from the service. Meghalaya police, my lord. He was a constable. He was a personnel there, my lord.
What was the infringement?
My lord, is a leave.
Unauthorized absence.
Yes, my lord. But then there was an application filed by him asking him for seeking for a voluntary service retirement, my lord. In the pending, my lord, he was. But now they have brought some factual aspects also, my lord, which we are not aware.
That means not aware your client suppressed it from you.
My lord, that's a reason I need to confront with my client, my lord. Need 3 weeks time, my lord.
Now we can dispose it of.
My lord, I'll take the instruction first, my lord, because
956 days.
My lord. But he obtained actually the medical leave also, my lord. He was suffering from some
Yes,
medical problems.
And after has been filed on behalf of the respondent number 3. Council petition submits that certain facts have emerged after it has been filed. He prays and is allowed 3 weeks time of instruction.
My lord. Much obliged. My lord.
12.
Your lordship, I'm filing the rejoinder during the course of the day. I've served a copy, your lordship, today. This
doesn't matter about.
This is regarding the non-teaching staff.
Who had been taken over by the Garo Hills.
CRG. Oh,
yes,
sorry.
Garo Hills.
By district council.
Yes, primary non-teaching.
Yes, sir. Mr. P.T. Sangma submit the rejoinder and we file the course of the day. Accordingly, list these matters for hearing.
Lordship.
2 weeks. Yes.
12 to 15 connected.
12 to 15, lordship. 12.
16.
Oblige, your lordship.
16, my lord, lordship. Today I have received the copy. The government have filed the affidavit, so I required some time to file my rejoinder. I have received only by today morning.
We'll be filing it today, my lord. We have served the copy, my lord.
Yes, Mr. N. Sukon appearing for 105 submits their appeal on behalf of us. Will be filed the course of the day. Stop. Just after 2 weeks for rejoinder, if any.
Lordship.
17.
Oh, yes, sir. Your lordship, this matter, your lordship, as per the last order, dated 23.
You've taken steps?
Yes, I have filed my small application for implementing those.
Where's that application?
I have given lordship to implement this new.
Where's the application?
This maybe on the
miss case. Where's the miss case?
I can miss case. It's there.
Miss case number. Yeah. There's the petition.
It's miss case number 112.
Okay.
Of
2006. Take down. This is an application. Miss case number 112 2026. An application by the petitioner for impleading and the 2, 3, and 4.
Yes, lordship.
Or 1, 2, 3, and 4.
1, 2, 3, and 4.
The respondent party's name herein as necessary respondents in the pending WPC number 664/2025. As the same as per the direction of the court, the applications allowed and the respondents number and the
4, 5, 6, 7, your lordship.
Shall be implemented respondents number
4, 5, 6, 7.
5, 6, and 7.
4, 5, 6, 7. as respondents 4, 5,
6 and 7.
The registry to make necessary corrections. This case allowed and disposed of.
Lordship.
Yes, in the main case, in view of the order passed in this case number 112, petitioner directed to take steps within 2 days on the newly implicated respondents.
Lordship.
Yes.
Marvelous Lordship. Apply, Lordship.
18.
Yes.
May I please hear Lordship?
Nothing
Lordship,
remains in your case.
Lordship, before coming to that, I would like you to take to Annexure 6, which is the representation filed by the petitioner before passing of the status quo order, Lordship.
That is over, MS Lau,
Yes, Lordship.
because the thing is that order to maintain status quo has been revoked also.
Lordship,
Then
revoking the status quo order without hearing the other party, the aggrieved party, it will be a violation of...
that's the new cause of action then.
Lordship, it will be a violation of principle
Close
of...
that petition now.
Lordship, my
You take a call, what option you would take, and then
Lordship,
if a new cause of action arises, you can come back.
Yes, Lordship, but Lordship, my humble prayer is that last time also I have the prayer that let this order dated 18/12/2025 set aside, let us allowed to file a new representation before the concerned authority. Lordship, in the Annexure 6, where my prayer is that Annexure 6, the prayer portion is on page number 24. Lordship, my prayer was that the impugned order dated 7/4/25, where the status quo order had been passed, and this status quo order has been revoked during the pendency of this writ petition, Lordship. Revoking the status quo order during the pendency of the writ petition, it is without hearing the other party, is a clear violation of principle of natural justice, Lordship. And the other thing is that the other three prayer, that is number 3, number 4, and number 5, the existence, if Lordship may allow me to read out the other prayer.
Prayers only for 8/12/2025.
Lordship, there are other prayer also, Lordship.
Where in writ petition?
Yes, Lordship, in the writ petition, Annexure 6, page 24.
No, my lord, the prayer is only to cause order dated 8/12, my lord.
18/12/2025.
They have not made any other prayer, my lord.
Lordship, in the prayer, kindly see the number 6, our sincere appeal.
Page 13, my lord.
24, Lordship, page 24.
Page 24 is what?
Annexure 6. Annexure 6 is page 22, and the prayer portion is page 24, Lordship. Here in my prayer, I have prayed for status quo order of the impute dated 7/4/2025, Lordship. In this case, recently the status quo order has been revoked by dated 18 March 2026. Lordship, the other prayer which I make, that is 3, 4, and 5. This is until date, this is not yet respond, Lordship.
But that's been withdrawn now. You file a fresh.
My lord, they have a new course of action if they are saying so, my lord. This writ petition is not continuing.
So MS Lau has been at pains to satisfy this court that the cause of action still survives with the revocation of the status quo ante order, which has been noted by this court. Revocation of the status quo ante order by order dated 18 March 2026, passed by the Commissioner Secretary, Education Department. The incident petition have been rendered infructuous. And as such is upon the close. However, the petitioners are at liberty to file a fresh.
Yes.
To address the new development.
19.
What about the petition?
Who's respondent number 9?
Lordship, respondent number 9, yes. Director General of Police, Assam, Your Lordship.
They appeared last time, no?
Lordship,
It's regarding that median.
Lordship, yes.
None appeared for the petitioner. This after 2 weeks. Yes.
20.
Apply.
Will you please, Your Lordship? Lordship, I pray for 2 weeks' time to file the affidavit.
See, I'm seeking 2 weeks' time to obtain status report, Lordship.
One number 5?
Yes, Lordship. Yes,
No?
one number 5.
1 second. Hi, Katuka. Karika, return to sender Katuka number 4. I can unlock one. See, Mr. Marang.
Yes, Lordship.
Say, please provide. See, this one is returned. You have to take 5 steps.
Yes, Lordship.
I can see. Let him see it. What's the matter about?
Family pension, Your Lordship.
This matter pertains to family pension, Lordship.
What are you going to do? You have to take 5 steps, but then you get the full correct address. See, they say at least add the, but they couldn't serve.
Yes, Lordship.
Add the, what's written there? There. Sender to?
Oh, please provide father name, Lordship. Or mobile number.
Yes. Yes, the notice on respondent number 5 has been returned unserved. Stop. With the noting for, because you see, return to sender, please provide father's name. Many these same names are living there in this place. So you have to give mobile number or father's name. But under the same name, there are many persons. You understand?
Yes, Lordship, I understand.
Yes, sir. For noting to the sender to provide father's name and mobile name, as there are many persons with the same name in the said area. Stop. Mr. Marak submits that he will take fresh steps.
Yes, Lordship.
The MS Sijala, what do you want?
To file an affidavit, Your Lordship.
Within 2 weeks.
Yes, Your Lordship.
Yes, MS Sijala vice Dr. Musica also prays for further 3 weeks time to file affidavit. Prays the list of the 3 weeks. Steps to be taken within. You have to obtain,
2 days, Lordship.
within 1 week, yes. Obtain the correct address. Yes.
Highly obliged. 21.
Lordship, item number 21 also pertains to family pension, Lordship.
All served?
Yes, Lordship.
All served?
Yes, sir.
Lordship, may it please, Your Lordship. Lordship, we are also required to file an affidavit.
Yes, MSc Jala, White or Music prays funds allowed. Further 2 or 3 weeks?
3 weeks, Your Lordship.
3 weeks time to file affidavit, yes.
Highly obliged.
Much obliged, Lordship.
22.
Your Lordship, this one service of notice affected yet no response from respondent number 5.
Has not been received AD card.
Yes.
You obtain status. Officer indicates that service not complete. AD card has not been received on respect of respondent number 5. Ms. LM Sangma responds allowed to obtain status to file affidavit necessary. You file affidavit.
I'm awaiting instructions, Your Lordship. I'm praying for some time.
MSZ in Country, Leonard GA, for 1124 responds allowed for 2 weeks time to obtain instructions and to file affidavit just up to 2 weeks, yes.
Highly
obliged, Your Lordship.
23.
Please, Your Lordship. I'm entering my appearance on behalf of respondent number 6.
Number?
Number 6.
What's the matter about?
We have filed the affidavit of service. It's
So
pension
what's the matter
benefits.
about pension matter?
Yes, Your Lordship.
Yes.
Yes, you, Mr.
Mr. E. Marpanya.
Mr. E. Marpanya has entered appearance on behalf of the Mr. 106 today. As such, notice accompanying all the respondents. Yes, what do you want?
We'll be filing our affidavit also in a week's time.
1 to 4 and EB Pasa. Not file affidavits yet. M. Sincon, GA for 1 to 4 and MS EB Pasa for 5. Prayer for and allowed for the 2 weeks time to file affidavit. Yes, similarly, so you'll file affidavit also. Similar time to respond, allowed to respond number 6.
Hearing from supplementary list, item number 3.
Yes. Where's the affidavit you filed?
Please, Your Lordship.
Where is it?
Lordship has already been placed on record. Even
No, where is it? It's in filed on 2nd of April.
2nd of April, Your Lordship. This affidavit, if may take Your Lordship to paragraph 5.
Oh, yeah, affidavit.
Your Lordship. The ones against the document produced by respondent 1 to 5. If you may please, Your Lordship. There's a discrepancy even in this document that has been submitted by the state, Your Lordship. In this document, dated 19 September, it stated that the church had forwarded the name of these contractors, recommending them for the contract.
Just catch your breath. Yeah. Just
And at the bottom of the same letter, Your
catch your
Lordship.
breath. Yes, one second. Okay, so your stand is that on the last date, RP General had brought out a letter showing that on 19/9/2024,
Gotcha.
the selection of contracts on the basis of letter issued by this the church, right?
Gotcha.
But then you see in paragraph 5 that this was done prior to that. Where's the document?
If I may just take Your Lordship to annexure 3, page 9 of the affidavit.
Yes.
Your Lordship, here, if I can take Your Lordship towards the bottom part of the page, Your Lordship, that the church had recommended their name and the same was also recommended by their local MLA, Your Lordship.
Where
And this
are you
was
reading
dated annexure 3, page 9 of the affidavit.
Yes.
And this was dated 19 September 2024. However, Your Lordship, if I may take you to the affidavit filed by the state.
MLA? It's not here.
It's here, Your Lordship, at the bottom of the page. Recommended
Okay.
member so and so.
Okay.
Then if I may take Your Lordship to the affidavit filed by the state in the annexure 4, page 32, page 35.
1 second. Page 35.
Your Lordship. This is the annexure R4.
Yes.
However, here the undertaking, Your Lordship, was signed on 16 September 2024. So how can the undertaking come first before the recommendation or before the names that were forwarded to the authorities by the church?
You know, read the undertaking. What is this? His name is there in the list.
Your Lordship, it is that number and number 8, as well as all the other names that have submitted their undertaking.
Yeah.
This clearly shows a collusive and a disparity in even the manner in which the undertaking was submitted before the concerned authorities as well, Your Lordship.
It says that I hear Devan to carry out the under mentioned work by following some. Somebody carry out the work even though the same have been sanctioned.
Your Lordship, they are undertaking here that they'll do the work eventually, then post facto whatever regularization is to be done, then thereafter they're gonna accept whatever payment that they're supposed to get from the department.
Yeah, but I mean, how is this possible? If in 19 September
yes, my lord,
the names had been sent,
yes,
and 16-year executive engineer whatever has
yes, my lord,
has obtained
yes,
undertaking.
Yes, my lord. I will explain what has happened, my lord. If your lordship will see,
no explanation necessary.
Yes,
the only thing is that in matter of public largesse now.
Yes,
now whether the state, as
yes, that is the first issue. That is the first issue.
Irrespective of what the project is for.
Yes, my lord.
That is in dispensing public largesse, whether it can be done such a manner.
Yes, my lord. That is
the property of, it's not the father's property
yes,
of the
yes, but that process has to be followed. I bow down, my lord.
Okay, Mr. Amit Kumar.
You do it with, yes, my lord. My lord, what my submission is, what my submission is, my lord, that your lordship has seen that there was some urgency in execution of the work. If I can take your lordship to my counter affidavit, because your lordship will have to keep in mind two aspects. This writ petitioner has approached in May 2025, my lord, because we cannot lose sight of the main issue, my lord, which your lordship has correctly brought us back to the main issue. Whether the award of the tender in this manner or work by the government in accordance with the procedure or norms laid down by the government. That is the core issue which my friend is trying to raise through the writ petition, my lord. That is the core issue. Now the core issue is, my lord, that your lordship has seen my counter affidavit on earlier occasion. I wish to place that once again, my lord. There are certain there are certain undeniable facts which have taken place in this case. One undeniable fact was that there is an urgency to repair the road. The second undeniable fact is that the sanction process would have taken time. Third undeniable fact is, my lord, that there are the local contractors or contractors which were nearby. Fourth undeniable factor is, my lord, that they have agreed. Even the local authorities or church have recommended their name. Now my friend is saying that look, recommendation is later, undertaking is prior. That is what my friend is saying. My lord, your lordship knows that when in these matters, it is not that the discussion will not take place. Discussion has taken place between the church and elders, but when it comes to writing in papers, there can be some dates here and there. Undertaking may be given by the contractor in 3 days prior, but these undertakings are only after some discussion or negotiation and identification, my lord. So from that discrepancy of 3 days, nothing is turned out. The question which falls for your lordship's consideration is whether they have been recommended by the local responsible entities or not, my lord. The need of the hour was to repair the road, my lord,
has these projects since then?
Yes, my lord. If your lordship will see what is the status, my lord. In fact,
they've been sanctioned now.
No, my lord, and they have not been paid single penny for last 2 years.
Well, they don't deserve to be paid.
My lord, they have because
already undertaken that it makes not a sanction.
they have not been.
Let them do.
They have suffered, my lord. They have suffered for public work, and because that kindly see the kind of state of affairs they have not been paid. I am not advocating their case, my lord, but the issue is that they have done something in good faith. It's not a case where the state has done something. Only two contractors. There some work is pending. 84% or something.
Work pending till now.
Because we have they stopped now. There's some culvert and some repair of the footpath, etc. Yes.
Your Lordship, if I may reply to the learned AG submission.
Has the work been sanctioned? Has it been?
No, my lord, it has been. I am informed that it has been sanctioned, my lord. The post fact, it has been sanctioned, and it has been sanctioned, my lord, subject to payment of. Now the question, real legal issue which your lordship has raised, my lord. If I can take your lordship to my counter affidavit, paragraph 4, my lord. And I bow down to the tenacity of the learned counsel for the petitioner, my lord. She has taken, and it's time to introspect for us also, my lord. Paragraph 4. That submitted the instant requisition is concerning construction and improvement of various, paragraph 4 at page 2, my lord.
Yes.
The submitted that the instant writ petition is concerning the construction and improvement of various link road of Nongstein of total length of 4.307 km. Petitioner purportedly claims to be a registered contractor based out of a different district, so and so, my lord, and has filed instant praying for issuance of writ in the amendments and seeking direction from this honorable court to stop all the ongoing construction and issue a published notice inviting tender for improvement of existing road, including MBT of New Nongstein, so and so. Before adverting to Parawai's reply, my lord, now we have said, my lord, the purported in 5.1 purported cause of action for filing instant petition has perished. Nothing survives for adjudication. 88.80% of physical work has been completed, my lord. Now in next paragraph, my lord, 5.2 in the instant writ petition, it is submitted, the petitioner submitted was aware that ongoing projects of improvement of road in on early around October 2024. It is submitted, it is no longer the delay. So the petitioner says that he was aware that work was going, and the petitioner has approached this honorable court only in May, my lord, that and rely on the judgment of the honorable Supreme Court. Now, my lord, after 2-3 judgments, my lord, then paragraph 5.5, my lord, purely private interest, because they have not met the parties. 5.5, my lord, larger public interest in certain, it is a question of larger public interest. It is a question of construction, because all these is the road could not have been constructed at such a short period of time. Now, my lord, I need not refer the judgments which I have cited on the issue that in the larger public and exigencies of situation, the tender is not must in all those cases. I have given all the judgments, my lord. Now kindly come to paragraph 12, my lord.
Yes.
It is some project for construction and improvement of various link road at so and so was formulated. It is submitted, process of sanction was started, estimate was submitted, executive engineer 29 to 24, my lord. Then, my lord, it is submitted, the process of estimate and sanction was going. Then JKP Senior Singh, a major church congregation in yes, my lord, your lordship, in February 2024. Yes, my lord.
This congregation was held in
25, my lord. Yes, my lord. The first was this, my lord. But the process, my lord, budgetary, because it's February, budget estimate has to be there, my lord. There was no budget in estimate.
Okay,
so
yes, let's hear the contractors.
Yes, my lord.
What do you have to say? How did you? This is a fact. You give undertaking before the. Before you even identified as a contractor?
There was a communication between the church as well.
No, how do you give undertaking? Under what basis? Did the executive engineer call you and say, hey, Mr. So-and-so, come, done undertaking?
Of the discussion.
Was a club among your contractors?
No, Your Lordship.
Yes? What discussion was there?
There was a requirement as
That's just the court wants to know. Now, okay, fine. That means to the exclusion of other people. If even the government said the database regarding contractors in the district, but not all, how do they pick up the database? We'll not go there. But we're just asking you now, if you signed undertaking 16.9.
There's already a communication, Your Lordship.
Where's the communication? Have you filed affidavit?
Actually, it's annexed in the affidavit of respondent 125, page 33, Your Lordship.
What did he say there?
subjects with regard to construction and recruitment.
No, this is not addressed
Your
to you.
Lordship, this is to the department. This is not to the contractors.
No, I want to know what is the communication between you and executive engineer. You just can't come from the road and say, I'm signing undertaking.
It was a verbal discussion.
By whom?
Between the church and the...
Forget about the church. The church has made a request. Now we ask the state respondents. Okay, the church made a request. Please kindly make this road. That's the request, fine. How the state acted after the request? Now, as per the documents they have given, it said 9. How were the contractors identified? They say that on 19/9, the church gave the list of contractors, correct? But then the other document proves otherwise. The undertaking signed on 16th.
They're already local contractors.
How were you identified? What happened between? How did you go to the office of the executive engineer to sign undertaking? How?
Because there was discussion and the need.
No, there's nothing. There's no tangible. It's behind closed doors.
See the church congregation.
Forget the church for time being. How did you go to the executive engineer's office to sign undertaking?
Since there was a need, they approached.
Who approached you?
The contractors.
No, who approached you? From the state side, who approached you to sign undertaking? Who approached you? This is just what we want to know. Now you signed undertaking, well and good. But who approached you? We can understand if the church had recommended your names 1, 2, 3, 4, 5. Fine. There might not be a tender. Other circumstances are there. Then, on the basis of recommendation, you were called by state respondent to sign undertaking that the work not being sanctioned, but you'll go ahead with the work, whatever may be the consequences. Now, how do you go before the church? Let that come to the church also.
The local contractors, they are aware of your lordship
So you just go to the engineer's office. Then tomorrow, so she can go to and say, I want to sign undertaking for some unsanctioned work.
in good faith, your lordship.
That's not a legal answer. You just want to know where's the gap. How did you go to the office of the engineer to sign undertaking? Under whose instructions? Who asked you to come?
File statement, then when did you come to know from church? Who informed you? All those aspects you place it on record.
We'll have to pass some directions here, of course. But the thing is that we just have to clarify these things. We're not holding you to that you're guilty of anything. Whatever you have done, that means, but this cannot be allowed to happen. It might not be a public investigation, but the person has a right also. It's a qualified craftsman contractor. And if there's work going in the vicinity, other contractors have a right to know. And the delay is not there because they won't know that's already finished, done and dusted, behind closed doors. And one fine day you see a road roller working the road and you say, how will this work happen? I was not know. That's why they came for the court.
The petitioner knew in October, my lord. And
That is why.
And October.
Please, Your Lordship, I'll reply to all the...
No, that's the only thing. That's the only thing. How, because it's point out in the affidavit. Your recommendation came on 19th. How did you on 16 only sign undertaking?
That's the thing, your lordship.
You can't explain.
Discussion was already there. Since the requirement, they wanted.
No, from the side of the state respondents, that's what the court to know. Who, on his own accord, he called you. Nothing. He has called you verbally.
What my friend is saying, my lord, that they were in the church. They are part of that church and congregation, and the issue was how to construct the road urgently. Sanction was not coming, my lord. Church leaders were also coming to the ministers and everybody. So then, probably in one of the meeting, it may have transpired that go and give undertaking. They have given the undertaking. Then the church, from church inquiry on
what government businesses.
This is
don't you think that?
No, but in certain, my lord, no, my lord, in certain greatest respect, my lord, in certain exigencies, that kind of leeway is there with the executive branch.
Can it be on the
No, the question is now how do we identify? Now, in certain situations, I understand there are certain aberrations that I can't say no. But the issue in certain situations, my lord, when situation like this, if I leave aside the present case, there are certain situations where we have to do it some parameters, because I did not pick and choose, my lord. It's not that the state's liking that I will identify contractor A and I will give it because he's my favorite. Here, these are the local contractors.
But submissions are made that we picked up from the database.
No, my lord, we have
no verification.
No, we have
There's
given,
no process in any manner.
In my counter, I did not say, my lord, that database, but he said that these are all registered contractors. They were given by the local authorities. they undertake only error and mistake which
they were given after the undertaking had been signed. That's the only question.
That has happened.
See, if you can,
that has possibly happened, Milord.
Recommendation came.
No, Milord. Sometimes understand. There is a gap. Milord. But that gap of 3 days, Milord. But your Lordship would appreciate that on Sunday there will be possibly a meeting of the church leaders and the contractors, and then they may have been directed, go give the undertaking. They gave the undertaking. Suddenly, in the matter, why are you giving the undertaking? Where is the recommendation? Then church may have given the recommendation. That is, it's not huge gap. Had there been a gap of 10-15 days, possibly.
I've never heard a legal argument like this.
My lord, the facts are such, my lord, where it is based on exigencies, my lord. And now the question, my friend, and the petitioner is seeking, set aside the tender, start the process. That can't be done, my lord. That's and then secondly is that your lordship is examining whether in case of exigencies, state is at liberty to grant the work to certain contractors or not, and what is the modus.
You see what is done also. Suppose there's a landslide.
Yes, my lord.
That needs immediate,
immediate in disaster cases.
Yes.
In disaster
so
cases.
that happens. That they have a SOP for that.
Yes,
how it's done. That's flooding. Suppose the disaster management, even PLUD have to clear landslide. That is done in a certain manner.
SOP has
and
to
yes,
be.
and that is regularized in all
No, I understand. That is the need of that. That
Exactly.
SOP should have been there. SOP at that I can't say. SOP
if they can put it, if they can implement that in other cases of urgent work.
That is the in order to curb the.
Out here, what it looks like, I'll tell you. This is like there's a small club of these contractors.
No,
they were
impression.
Good books of the,
Milord,
the church. So they're leaving aside the other congregation members. They give in the contract.
No. This is the one of the your lordship has seen so many. This is one of the odd cases which has come before your lordship. In so many cases where we have followed the tender to the hill. Process has been. There may be complaint here and there, but the fact of the matter, it is a case where congregation was there, church leaders were anxious, sanction was not coming, the process was slow, my lord. If for 4 kilometers, how many contractors are there? 9. 9 contractors, my lord, and they have not been paid for 2 years. There is not so much money in this, my lord. Only thing which your lordship is examining is very process.
This is for 6 crores.
6 crores. 6 crores, and they have done the work 100%, my lord. In 6 crore rupees, if I take the margin, not more than 10% margin, my lord, or 15% margin, and church was supervising their work also. Congregation has happened without complaint, my lord. That those kind of situations, your lordship, this is not one of the cases where I have favored one contractor from my book and gave it to him.
Up to what is the financial capacity of the executive engineer? To what?
My lord, that I have said. So if your lordship will see my financial capacity, which I have clearly said a word in my counter affidavit, my lord. If I can take your lordship to the relevant paragraph.
So when it's chief executive engineer.
Yes, my lord, I have said so. He is there, my lord. I'm sorry, my lord, I am pointing out the.
So you see 6 crores within 9 contractors.
That is less than 50 lakh rupees, my lord.
Where is that?
Your lordship will find paragraph 20, page 22, paragraph 24.
Executive engineer 50 lakhs.
Yes, technical section of repairs on so and so. That is R5, my lord. If your lordship will see R5, and this is up level up R5.
The next R5.
Yes, my lord.
Yes. Where's the?
Yes, your lordship will find that 45.
45.
Yes. And what was awarded by
45 public
yes, my lord. Then a court technical and ordinance chief. Now your lordship will find rules made financial 2021 public health engineering chief engineer equivalent full power extent of power superintendent.
Original work 6 lakhs only.
But this is probably, my lord, this work may have been, but on the file because the undertaking has been given to in the file, it must be, if your lordship will see chief engineer only, my lord, delegation of. They may have given the undertaking to executive engineer, but the work must have been approved at the.
So when the work was sanctioned, it's under whose hand?
It is probably at the level of, my lord, that I have to check it, chief engineer only, not below that, my lord. That is what, if I can take your lordship to paragraph, public work department, same thing, public work department of PHE 47.
Yes.
Now, if your lordship will have page 20. And the parameters also in page 22, paragraph 24.
Chief Engineer has full power. Fine.
Yes, Chief Minister have full power.
By whom?
That will be probably up to the level of Chief Engineer. You have yeah.
Mr. Sinkra, we didn't get any papers after you finish your work.
If I may submit, your lordship.
Unnecessary suffering also.
If your lordship page 10, if your lordship will see page 10 of the page 10 of the additional affidavit. No, that is different, my lord. That is they came out with some rejoinder in which they showed some different road, my lord. They made false statement also. I am not 340.
I'll bring
I
your
have not
lordship
filed
to that as well on the statement made by learned AG.
If you see, if I can show the rejoinder, they have shown the photograph of some other roads.
Where tender process was not carried out, and the reply of the state to that effect as well, your lordship, I will bring.
And this has nothing to do with this the instant project, and photographs of the other roads have been filed, my lord.
No,
We could not
with
file.
regards to certain statement, your lordship,
for the council, we could not
that
take
this is a
action.
rare case. I'll show to your lordship how there was in another project as well, no tender process was issued, and in the very reply in the additional affidavit at para 7, your lordship, where it was stated that the project was stopped because it was undertaken by some other agency individual on their own expenditure.
And that was being projected by as a project which was being constructed by these contractors in rejoinder.
Your lordship,
And this is that case has nothing to do with that issue, has nothing to do with the present writ petition, my lord. So this is how they wanted to mislead this honorable court.
No, your lordship, this is a reply to a statement made that this is a rare and exceptional case, your lordship. That is not the case, your lordship.
This case, incident.
No, what learned AG had submitted that this case is a rare incident, but however, even in other projects also same manner has been carried out.
It's in the nature of, if I can show, my lord, the averment in the rejoinder, because I have read that. In the rejoinder, but I am not going into that issue, my lord. The question is, my lord, if your lordship will, the chief engineer has the full power. It has approved, and
you just want to see that sanction. You just bring it.
Yes, my lord, that is there, my lord. If you'll sanction is there, my lord, in additional affidavit. Yes, my lord. If your lordship will have that page.
Your lordship is there in the writ petition on page 36 and next 8.
96. Page 36.
Your lordship. And your lordship, even though there's unlimited power, that cannot be untethered, your lordship. A certain procedure has to be followed.
And we have followed certain procedures in the case of exigency. We have appointed the contractors who are registered. We appointed the contractors who agreed that they will not receive money till it is sanctioned.
Process verification, and regarding the urgency, the plea to that.
And they are all local contractors and church leaders also.
Local, place as well.
Yes, anything else?
Nothing, that's all we
Your
have.
lordship, if I may reply on the delay aspect, I've written a short note, if I can submit that, on the delay and why we had come only in May regarding the construction of this project, and regarding the financial powers that the competent authority has.
Work is going on. My friend's client know that there is no tender. Still, he sleeps over his right for 9 months.
Your lordship, that has all been explained, and that was previously already argued also, your lordship.
No, I don't want to do anything, my lord, but the question is what right my friend is having. My friend's client is having.
I have a right to participate.
And the statement is made that in work is going in October and approaches this honorable court only in May, my lord. That I am not only on the
And
limited
lordship,
part,
that has
my lord.
been
Only on the
clearly
limited part.
clarified and stated also why had it come only in May as well, your lordship. And your lordship, even in the
My
matter of
friend would have
urgency,
applied
also the state cannot
RTI
just
after 1 year, then that would have been said
That's
that
because the construction was known to the petitioner only in the month of October. That was when the construction started as well, Your Lordship.
congregation was over, road was constructed.
Everything done behind closed doors.
Exactly.
So
Your
even
Lordship.
because before
No,
the
it was
judge
not.
recommended also.
No, my lord,
they already signed unless-
everything was known to my. I'm only on
Your
the issue
Lordship,
of limitation.
the knowledge
my lord.
came only on
Ye
October
delay
2023.
part. Only
And
on the limited
Your
part.
Lordship, if I place a judgment, even in cases where there's urgency also, they cannot do away with
Which
the
judgment? You annex
procedure.
it here.
This is the power carrier judgment. Your Lordship.
And my lord, I have also placed
That is a case where
RTI application was moved on 14/10, my lord, 2024. Reply came on 20th November 2024. my
Your
lord.
Lordship, when we filed appeal against that, so there was no reply. That's why we were forced to come before this honorable court.
see, Mr. Arpitan, she's using the same case that I argued as senior counsel, and where the contractor he does not get. I lost this case. I mean, we were asked to pay him compensation because what happened was our person being only qualified,
Yes, my lord.
transmission provider, power transmission provider, was urgent work was settled with the contract.
Yes, my lord.
That's all.
I cannot be denied of my equality to participate in processes
nobody is denying,
concerning
Lord, but in certain
state largesses, Your Lordship. Even here, the urgency has been explained, Your Lordship, when the knowledge came to the church and how the manner in which they have approached the state
See
respondents
what
as well.
the division bench said.
Paragraph, my lord, page.
Page 37.
Page.
Having said thus, would have considered taking up the process of raising a reasonable amount of compensation while compelling appellant company to disgorge some portion of profit earned on illegally awarded contract, and the appellant board also to share such burden when conducted a proceeding in unfair manner. However, such a process appears necessary. The appellant appears for us by way of alternate submission. The offers was made earlier responded and not accepted. So, in this case, yes, I remember. So because what happened was without a tender,
Yes, my lord.
he settled
Yes, my lord.
and just called and made to
It
do
was
the work.
cancelled and after they
And
gave the work.
That is a
On the
factor.
grounds of urgency.
Probably
only,
that
Your
is the
Lordship.
factor which is weighing with your lordship also in this matter.
So, yes.
And kindly note, Your Lordship, the way the contractors who were recommended also, Your Lordship, there was no verification of any sort carried out, and how these contractors were brought about, there was no notice from the church saying that there's urgency. At least there should have been some sort of an announcement, Your Lordship. Some sort of an announcement should have been made, Your Lordship. It cannot just be on the recommendation of the church and their local representative.
No, that won't come here anyway.
Go through
Reserve
anyway.
kept copy. You want to make new submissions? No. Yes. Then we'll pass orders.
Grateful, man.
I do pledge, Your Lordship.
Item number 4.
May it please your lordship. My lord, this is coming for the disposal of this case, my lord. Before I take my lord to few incidences, my lord, where I like to. There was a affidavit in opposition that didn't file, my lord.
One second. You received this after reply file today?
Yes, I have received in the morning, my lord. But I have gone through, my lord. There's no documents to annex. There's just a mere statements, my lord. And before I come to the merit of my case, my lord, I would like to counter one aspect in the affidavit that has been filed before my lord today. Page 3, my lord, where they said, page 2, the last point, para 5 and Roman 5, my lord. That's they've stated like this, my lord. The applications and requests made by the petitioner and her family members to issue dulir in the name of the following persons are still being looked into by the Dorbash Nong Ding Passo, and pattas were issued to the following names herein after proper verification. So four of my children have been issued with a patta. 2 of them have been issued with a patta, and the way they have pictured that over my 10 plots of land which is before my lord, it is not a fact. Here 2 of the 2 pattas were issued to my children, my lord, because my children have bought this property, my lord, from the Shnong, my lord, as a small plot of land which they have brought out of their own money, my lord, out of their own fund. They have issued a patta on those properties, my lord, not on the properties that we have been enjoying, my lord, for many generations, my lord, not over those properties, my lord. Now my lord will see my writ petition at page 3, my lord. Page 3, paragraph 4. May I be permitted to read this paragraph, my lord? Paragraph 4, my lord. That the petitioner and her family are one of the first residents of Dingpaso village. The petitioner and her family has occupied and cultivated various plots of land in her village since its inception. These lands spanning over 10 plots were, so these are the identification of all the plots, my lord, up to plot 10, my lord, up to plot. These are the plots, my lord. So now initially, my lord, when Dingpaso came into being existence, so there was no practice of issuance of patta or dulir at that point of time, my lord. We were allowed to cultivate whichever plots we are cultivating, we are allowed to cultivate, and these are the right land, my lord. So therefore we have been in continuous occupations, my lord. Now the concept of issuing patta came only in the year somewhere 2022 or 23, my lord. Why? Because of expansion of more people coming towards that, more people buying plots of land there for commercial interest or for residential, my lord. So that is the time. So now there was a measurement of all the plots of land. Even my plots were measured, my lord. The 10 plots were also measured, my lord. That is how I've come to know, I have come to get this measurement also, my lord. But whereas when all the other land or the plot owners, my lord, the occupants were given issued with patta, we were singled out. All over this plot of land we were not given. Now, because of which, my lord, we had to, the first letter we have written to the Dorbar, my lord. Page 31 is the first, that's the English translation, my lord. The page 31, my lord, may kindly come to page 31. That's the English translation, my lord. So when the pattas were not issued to my family and
so in short, the short of the entire dispute that this Shinong trying to grab the land, that's all.
They have grabbed my land. That's the thing, my lord. That's good. Now,
why
my lord,
done that in land? Why you grab private people?
My lord, we did not grab their land. We are saying that we are, as per my submissions, my lord, we are conducting verification and
What
surveys.
verification has already been done by the Bakhraus of
Yes.
No, my lord, that has not been done. This, you see, my lord, the
what
executive
is the
committee.
report given before this, before the CM Khadim then?
That is a report that says that we have trespassed to their land.
You have
That was the
trespassed on
report.
the land, yes.
So my lord, but these lands don't have land documents. So we are yet to issue them land documents.
Then that means
My lord,
like
we
that we call that wrong Bachnong here.
My lord, we cannot. My lord, we cannot issue land documents until and unless a survey has been conducted.
What survey? You and I know very well what survey is done
My
in
lord,
this area.
my lord,
It's
the
from
survey.
that tree there to the
No,
mountain
my,
there,
my,
the stream here.
My
to
lord,
the,
my lord, please
there.
refer.
Then
My lord, please refer to para 11.
they have given schedules here. If the schedule is not correct, then fine.
Yes.
See it. Where's that paragraph?
My lord, these schedules.
Will give you 1 week's time. You verify these plots, given writ petition, and you can give a report.
But my lord, allow me to submit also.
We'll allow you to submit, but from what we can see is that only thing. You're
But
saying that we have to verify it.
My lord, these lands were cultivated by the petitioner. However, they do not. They are right land. They cannot owe these lands. They are right lands. So
What
my
does
lord,
CM say? The right lands or the individual lands? Who's the
they are
paying
right
for the
lands.
CM?
There is a letter from the same also, my lord. I'll show you the letter from the same.
You have to have occupancy right. They have to be issued patta also.
Yes, my lord.
Occupancy.
That is
Then
there, my lord. But my lord, we cannot just issue pattas, my lord. They are with a growing population.
show a sample of any other patta I've issued. Kindly bring it tomorrow.
I'll bring it, my lord.
My lord. Yes.
We'll bring it tomorrow.
All I'm
Are
saying.
people available in court today?
No, my lord. All I'm saying is that, my lord, the committee has decided to.
Yes, an affidavit reply has been filed today itself. by the respondent number
4, my lord.
the number
4.
Number 4. The MS Bank submits that the Darbar, who's the Sardar and the
I'm only for respondent 4, my lord.
have not issued the pattas as the team to be verified in a proper manner. Have you verified the issuance of such patta? So this court on this submission deems it fit to direct the respondent to produce copies of patta that issued to other lands in the vicinity. Yes. We'll listen next week then. Please produce it.
Yes, my lord. But my lord, please allow me also to submit. I'll also satisfy the court.
If people are holding land, you can't. You see, you can't have might is right.
No.
It's happening in many things. Now, whenever land acquisition is there, what happens is that even if the person has been occupancy, you understand how
my lord, interested
how
parties
compensation works.
Yes, my lord.
Even if you're not the owner of the land, if you have structures there, your occupancy rights are there, you have to be compensated for that. Doesn't mean that now one fine day if the alignment's given, the Shillong comes and says, oh, it's come from here, so kick out these people. It belongs to the Shillong.
Yes, my lord.
That can't happen.
Yes, my lord. It only happens. My lord, it only happens that you also have internal dispute between the family.
No, that is.
They are claiming from each other. So, my lord, who do we issue pattas to?
No, that is wrong, my lord.
It's there, my lord. It's there in my submission.
It's irrelevant, my lord.
Or you do your verification.
Yes, my lord.
This court not
If they do not
now
file any more.
especially all disputes are coming. This entire Dauki Peninsula Road.
Yes, my lord.
This east, what's this western bypass? What's happening?
Yes.
I understand that, my lord.
One person goes and he goes and gets a compensation, then the court follows from behind, then the Shillong comes from behind. What is this happening?
No, that is there, my lord. We are not against issuing patta to them. We are only saying
everyone
that.
wants to have the fingers in the pie. That's all.
My lord, we are only
Simple
saying
as that.
that, my lord, proper
If
verification has to happen. We have to give everybody land, my lord, not just this family. There are
They
other
are
families.
occupying. You don't have to give them. You give them patta. Why
My
should
lord,
give
we
them
cannot
land?
just give them patta, my lord, because the population is growing. There are people who are already applying. The committee has decided.
That kind of submission does not hold any water. Suppose MS Bank holds 100 acres of land, customarily.
Yes, my lord.
Now one fine day the Shillong say, no, many people are staying there in Malkira, they need your land, so we'll distribute them. The land. Will you allow it?
No, my lord, but
Then-
what I'm saying is, my lord,
Much of
we are giving them what has been verified. We will give them pattas. Most obliged, my lord.
Yes, Mr. Rupra. Yes, Mr. Shulai.
Lordship.
We dispose of you. Look into representation.
Lordship, Lordship, it can't be. Lordship, there is, if Lordship kindly have our affidavit.
Yes.
If Lordship kindly have, that is at page 18, your Lordship.
1 second.
Because, your Lordship, what happened there? Page 18 of our affidavit, your Lordship. That is. Lordship, we filed the affidavit, your Lordship, Annex 1 at page 18, your Lordship. This is the case of this is the judgment rendered by Lordship. If Lordship kindly have para 10 at page 29.
When was the judgment passed?
Lordship, this order was passed on 28/10/2022, your Lordship. The judgment of the Honorable Supreme Court, Lordship, in which the petitioner had relied, your Lordship, that was rendered on 30/9/22, your Lordship.
Okay, come to para.
Lordship, kindly have page 29 at para 10, your Lordship. May I read it, your Lordship?
Yes.
The above noted judgment of the single bench was thereafter upheld by the division bench of this court, and the Honorable Supreme Court on the SLP preferred against by the order the tender had not interfered with the said judgment, but only directed the consideration of for relaxation for being eligible to sit for MTET examination. Then, Lordship, I skipped that. What Lordship? Then, Lordship, kindly have page 33, your Lordship.
Yes.
Lordship, page 33, Lordship, para 14. The writ petition accordingly stand dismissed. However, before parting with the record, as the petition so as stated to have since qualified the MTET examination, the state respondent shall accord due consideration to allow them to participate in any further selection for the post of assistant teacher. So, Your Lordship, the admitted fact here, Your Lordship, that all the writ petitioner here, Your Lordship, they have qualified their MTET in the year 2023 and 2025. So, Lordship, when future selection process to be undertaken by the state,
they are asking to accommodate against those vacant posts.
Lordship, that has
have you advertised for selection?
That already advertised, Your Lordship. Lordship, Lordship, kindly see, Your Lordship. Just a minute, please.
Yes.
Lordship, kindly see, Your Lordship. They were they were contractual appointees, Your Lordship, and they were discontinued in the year 2020, Your Lordship. Then subsequently, Your Lordship, came the advertisement, and all those posts were filled up, Your Lordship.
They took part in the selection.
Lordship, no, because at that time they don't have that eligibility criteria, Lordship.
At that time, they took part in selection.
In this case, we are not some who has cleared the MTET in 2021. They are participants, but those who are mostly they are who just was out in 2025. So
No, what you're seeking here is that you said as per your RTI queries, presently they fired and something post vacant.
Lordship,
yes,
yes, and so you are praying that you be considered against those vacant posts.
Yes.
Not through selection. I mean, for direct recruitment.
You're by
yes, Miss. Yes.
If my lords can repeat the query, I would be able to assist.
No, you see, the learned Additional Advocate General has placed this judgment 28/10/2022, whereby the writ petition was disposed of by saying that since qualified for these MTET, they'll be allowed to participate in any further selection for the post assistant teachers. They said that since the order is already there, so it's up to you to take part in any future selection.
This is my fair submission, Your Lordship. I'm submitting fairly, Your Lordship, on this.
Yes.
I bow before my lords. In fact, I do appreciate what has come from the state, but my lords may have page 5 of the counter affidavit. And why the need for a petition like this where representation is not decided? My lords have page 5 of the counter affidavit. This is para 1 of para-wise reply that the state has filed.
Yes.
They named 3 petitioners, petitioner number 3, petitioner number 38 before my lords, and state that they had qualified MTET in 2021 itself. Now, my lords, the indulgence that we need is for cases like this, they will complete their 7 years in 2028. Admittedly, there is a vacancy. We don't say it's a matter of right.
Yes.
Point is, either they want to fill the vacancies and they want to proceed with doing that, has to be a finite time, because the statutory indulgence, the time that I have is only 7 years. If Meghalaya so chooses to conduct the next recruitment in 2031, I have missed the bus. I cannot ever be an employee. I cannot ever be a teacher again. So the grouse is not that I have a vested right to be recruited. Point is, there has to be some method to it. There has to be some mechanics by which they are doing it at regular intervals. Conducting the MTET also doesn't help till Meghalaya doesn't.
I think, Your Lordship, the MTET certificate, Your Lordship, is valid for life, Your Lordship, not for 7 years as Your Lordship. I think it's for life, Your Lordship.
Where 7 years? Where is it shown 7 years?
Lordship, I do not see. Where is that 7 years, Your Lordship?
I will just take my lords there.
I don't know past 7 years. I don't think, no. Because once I pass my LLB, Your Lordship, I cannot reappear again for LLB after 5 years or 2 years, Your Lordship.
Different because there are new teaching methods. You have to requalify also.
Lordship, if Lordship kindly have page 56A, Your Lordship. This is one of the certificate, Your Lordship.
Petition.
Lordship, of the writ petition, Lordship, yes.
56A.
56A, Your Lordship. Lordship, yes. Lordship, if Lordship kindly have that instruction 2, your Lordship. Instruction 2, your Lordship. May I read it, your Lordship?
Yes.
The MTET qualifying candidates, unless otherwise notified by the appropriate government, would remain valid for life.
Yes.
Lordship.
Mr.
My lords, may just have
How come it's
page 42, my lords. These are the MTET rules by the NCTE, National Council for Guidelines for Teachers Eligibility Test, notified by NCTE in 2011 itself. It starts at page 37. My lords, has the first page?
Yes.
This is 11th of February 2011.
Yes.
And the next page is where the guidelines start at page 38. Now, my lords may have page 42. This is Rule 11, Guideline 11 at page 42. My lords, has it?
Yes.
Frequency of conduct of TET and validity period of TET certificate. The appropriate government should conduct a TET at least once a year. The validity period of TET qualifying certificate for appointment will be decided by appropriate government, subject to a maximum of 7 years in all categories.
Lordship, that is...
It can't go
right.
It can't go beyond 7. It's not the other way around.
So you don't have the latitude, Mr. Shulai, to save for life.
Lordship, where is that?
But there will be no restriction on the number of attempts a person can take acquiring TET certificate with respect to the age, which is 37.
Lordship, this is the certificate issued by the government, your Lordship. Yes, it's very clear, your Lordship. Unless otherwise notified by the appropriate government, would remain valid for life. You cannot go back from this, your Lordship.
Now, what about this guidelines? That 42. They can give any time. They can say 1 year, 2 years, but maximum 7 years. How do you reconcile that?
Lordship, the instruction is very clear, your Lordship.
The instructions are very clear, but then there isn't conflict with the guidelines of this NCTE.
But Lordship,
and if you're following NCTE to implement MTET, the teachers
Lordship, be that
test.
as it may, your Lordship. Be that as it may, your Lordship. Because, your Lordship, I have submitted very fairly, your Lordship. They have now...
It works to your advantage if the state cannot reject your applications now.
Lordship, they have the required qualification, your Lordship. The state will advertise those posts, your Lordship. They are free, they are welcome, your Lordship.
Take down then, yes. Take down. The brief facts of the case is that the petitioners herein were contractual government teachers. How many petitioners are here?
45.
The petitioners herein numbering
45.
45.
45.
45.
Lordship, if may I interrupt, your Lordship? Lordship, my friend is heading over, your Lordship. If I may read, your Lordship, there is a validity period of teacher eligibility test qualifying certificate extended from 7 years to lifetime.
By where?
Lordship, this is
by the NCTE itself.
Press Information Bureau, Government of India, Ministry of Education, your Lordship.
Where's the notification?
Lordship, if my friend will share with me, your Lordship.
Which friend shared with you just now?
Please come here.
No, then she doesn't have the copy.
It is here in the mobile, your Lordship, in the mobile set, your Lordship. If Lordship allow me, I'll just take a printout. Just now only, your Lordship. My friend will go.
Go where?
In our room, your Lordship.
Notification is there online.
It appears, your Lordship.
My lords, I think there is one. The learned AG is correct. This is of 9th of June 2021. I also just now checked. Can I present my screen, my lords?
Yes, just present your screen.
I'll just do that, my lords.
Lordship, this is the declaration by the Honorable.
Then present the screen, the notification. Just share your screen.
Yes, my lords, I'm trying to do that. My lords can see my screen.
No. Yes.
Is it visible?
Yes, visible. Now just hold it there. Yes.
Please, my lord.
It was 9/6/2021. Oh, para 11 years of the guidelines. Fund teacher is also issued by so and so. Okay. So that settles it. Yes. 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 So then that limb of your argument goes, Mr. Singh.
That goes.
Yes.
I admit, my lords.
Then you will dispose of.
Lordship, I'll have a, just now we'll have a.
Not necessary.
Lordship, ask Lordship places.
I take down. The petitioners are numbering how many number? 45.
45.
Who are contractual government teachers teaching in lower primary schools before the termination on 15/12/2020 on not having the requisite qualification of MTET. Stop. The grievance projected in the petition is that after 2019, the government has held only 3 examinations for qualification of MTET, and that and the petitioners having since qualified. However, there has been no fresh recruitment to numerous vacant posts that are available. Stop. Mr. V. Singh, learned counsel for the petitioners with so and so, has submitted that by an RTI query, they have come to learn that there are 563 vacancies presently available in the post of assistant teachers. He submits that the petitioners are also apprehensive that if selection or consideration for filling out this post is not taken up expeditiously, many petitioners would be rendered overaged. Yes, in spite of having the requisite qualification. Stop. Learned counsel has drawn attention to this court to representation dated 18/8/2025, annexure A2 to the writ petition, and submits that though the same has been and submits that the same has not been given due consideration till date by the respondents. It was respondents. Now you've all appeared and all qualified.
Lordship, yes.
Yes. So that in service thing won't come in. They'll not be relevant. Yes. Yes. We therefore praise that appropriate directions be passed to the respondents to initiate immediate steps for filling up the vacant posts, and that the petitioners be given due consideration if any other method of filling up the vacancies undertaken, considering the past service and the fact that they have attained the required qualification. Stop. Next, Mr. N.D. Shulai, learned AAG, in reply, has submitted that the petitioners have no vested right to claim for appointment against the vacant posts. In this context, the learned AAG has referred to the judgment. Where is that?
Lordship, page 18 of our affidavit, Your Lordship.
It's referred to
page 18, Your Lordship.
Page 18,
Lordship, yes, and the relevant para 10 at page 29, Your Lordship.
The judgment is court dated
28/10/2022, Your Lordship, at para 10 and 14, Your Lordship.
Number 369/2020 and other connected matters.
Lordship,
where he submits this court after going through the entire history with regard to the claim of the similarly situated petitioners on the aspect of it's not an MTET.
Lordship, yes, MTET.
It's not MTET, on the aspect of
MTET, Your Lordship.
on the aspect of the MTET qualification.
Lordship, yes.
This court had observed that the state respondents, in the event of any selection, were to allow the petitioners therein to participate for the post as a teacher. He therefore submits that as no advertisements have been issued for the present vacancies, then no case is made on writ petition, inasmuch as and when the same is floated, the petitioners will naturally be eligible to.
They can have also age relaxation also, Your Lordship.
He further submits that in such a case, if the question age relaxation is required, the same shall also be positively considered by the state respondents.
Well, it's just one request.
Yes.
Well,
Yes.
this judgment, the judgment that the learned AAG is quoting is of October of 2022.
Yes.
Admitted situation is for over 3.5 years now, there has been no recruitment process. And that is exactly what our grievance
Yes.
was in the representation.
Yes, anyway, that's fine. Yes, having heard learned counsel for the parties, it is seen that the only issue in question is the only issue in question, not issue, the only grievance of the writ petitioners, not issue, is that firstly, the representations dated 18/8/2025 and 23/9/25 not be considered, and also an added prayer has been made for consideration by the respondents for the priest's regular appointment to sanction posts as per the eligibility and in light of the Supreme Court directions and other in light of the Supreme Court directions and other government guidelines and policy. Stop. It is noted from the submissions and materials that have been placed that admittedly there are 563 vacancies as per the RTI reply received on 6/8/25, correct? 6/2025. And from when was the last election held? 2022.
Lordship, I think
and that from, you just verified that, and from the last election process which was conducted on
21, Your Lordship. I think
it was conducted 21.
Lordship, I'll have to find out, Your Lordship. The last
we don't know exactly. Yeah.
Last election process which was conducted sometime 2021. Though many vacancies existing, there has been no fresh, there's been no fresh appointment of teachers against the said vacancies. Stop. Next part. As the issue in question is very short, notwithstanding the representations that have not been disposed of by the respondents, considering limited prayer of the writ petitioners, and also the fact that the MTET qualification by a notification by notification dated 9/6/2021, whereby the validity period of the MTET has been made valid for life. This petition is disposed of with the directions that the seat respondents take steps expeditiously to fill up this 563 posts of assistant teachers, considering the need and considering the long lapse in the recruitment process, and also the fact that the qualified teachers such as lead petitioners are without employment since the termination without services in 2020. So, should we give a time frame?
Lordship,
Yes, with about us, and if nothing, as nothing remains constitution, the petitions accordingly disposed of. Yes.
Just one thing, my lords, that noted last recruitment, that RTI reply, my lords, provides in item number 5 that the total number of teachers that were recruited in lower primary from Meghalaya.
When was it?
November 21.
November 21.
There are 177 teachers who are recruited in 4 years, 2021 November till 2025 June. That RTI.
Okay, we'll add that page. We'll add it later. Page
29.
Page 29.
99.
Page 99. Okay. Thank you.
90.
Right. Next.
Apply, Your Lordship.
Deeply obliged.
Hearing from daily list item number 30.
Yes.
Lordship, the petitioner is here claiming for the lump sum compensation with regard to the discharge on low medical category from service. Lordship, may I take to an extra for 13? The petitioner has received a communication after sending the legal notice by his appointed counsel.
What is this instructions? That he last time produced?
But the instruction was that he was discharged on the low medical ground of hypertension, my lord. So the question was whether any assessment was done, how much. So the instruction is that for a case of hypertension, my lord, there is no percentage can be.
Suffered from primary hypertension?
Yes, my lord.
If the government service boarded out of government service on account of his disablement, the quantum disability pension for 10% shall be.
For that, there has to be permanent disability, my lord. And hypertension is not a case of permanent disability, my lord.
Now, what's the difference between low medical category and disability? What's the distinction?
But low medical category is that if he is found unfit for soldier duty, my lord, normal armed duty.
Not because of illness.
Not because of illness, my lord.
Low, but medical category LMC.
Yes, my lord.
Then?
But disability is something like more serious, my lord. A low medical category, because once somebody is discharged on low medical category,
now,
he is entitled to all the benefits.
Persons who are discharged under low medical category can also be given disabled pension.
No, my lord.
No. They cannot be given pension.
No.
They cannot be given
because there has for
compensation rather. Sorry.
For determination of disability, there has to be a medical board, my lord, and then he gets some extra pension for that, my lord. But for that disability, my lord, it has to be attributable to the government service and
in service, which incurred during in service.
Yes.
No, but this low medical category.
But low medical category is only a misnomer, my lord. Here, what happens, my lord? This is
now you've written here, it's written here, in permanently placed LMC cases, assessment of disability percentage shall be reflected on each occasion. Meaning?
But here what happened?
Including non-aggravating attributing factors, findings of the commission of inquiry, if any. Now that means that suppose his hypertension is caused by his
attributable to service.
Attributable to stress.
Well,
that we take into account.
They were too remote, my lord.
But it's written here like that. I'm just trying to understand your letter only. See, you read the para 3, that page 3 of your note. I mean, of this letter.
Yes, my lord.
I don't
Because this was just in response to the query that was put before me, my lord. So I sent that query and this is a reply to that, my lord.
Exactly. So that this reply should answer the question.
But if I may, it was just to place in perspective, my lord, here what happened, my lord, in this case. But around 2015, my lord, and till then, there was a practice in Assam Rifle that those who have completed 30 years of service or those who have attained 55 years of age, my lord, there was some kind of assessment was done whether they are still fit to be continued in service, they should be discharged. Primarily on the ground of low medical category may not be the correct word, but whether physical fitness, my lord, physically they are fit or not to discharge.
But shape 1, shape 2, that's different.
They have to be in shape 1, my lord.
They have to be in shape 1.
Shape 1. Or can be temporary.
Disabled didn't say then shape 1. Where did it say?
It is there, my lord.
It's there. You're in what shape?
It was para 4, lots will see. In the same letter, para 4.
Yes.
However, in the instant case, the petitioner was placed in low medical category P3, T24, with effect from 9th April 2014 for the primary hypertension and upgraded to low medical
disability.
P2, T24. T means a temporary melody for 24 weeks.
No, for the disability, primary hypertension. Now you say primary hypertension is not a disability.
It's not a disability as such, my lord.
It's written here that a disability, primary hypertension. It's very confusing.
It's a wrong selection of word, my lord. It's simply a wrong selection of word.
That's why the school is trying to understand. In view the above submitted petition is not entitled for lump sum compensation. Because now it comes in that you said now he was not in LMC, he was in temporary LMC.
Temporary LMC.
And in temporary LMC, how should he be discharged then?
My lord, I'll just take your lordship to a previous order passed by this honorable court, my lord. That lordship will find. The lordship will find at page 127. My lord. Sorry, I'll take your lordship to the previous order.
Which page?
Justice since order, this is. This order starts from page 44, my lord.
Page 44?
44.
See, one thing we're trying to understand also, see, Dr. Mozika, now Supreme Court, other cases regarding disability, they've passed those kind of judgments. Then again, we have to split hairs. What is disability?
Yes, well, here what happened, my lord? Under Rule 56J of the CCS rules, my lord, a service review was carried out on completing 30 years of service or attaining 55 years of age.
Yeah, that's that.
Whether
Many
they should be
cases
continued in service or not, whether physically and mentally and fit in all respects or not. That was not this was simply a sort of exercise, administrative exercise, my lord.
Assessment.
No stigma attached with that. And if they were discharged on that ground, my lord, they'll given full pension, full all retirement benefits, but they're sent home, my lord. They're not allowed to continue beyond that. So that was the only aspect of that. Now, in 2015, this exercise was carried out for more than 100 petitioners, my lord, 100 of the Assam Rifle Jawans. They all approached this honorable court.
Yeah.
Now, the learned single judge of this honorable court said that fitness is of paramount importance in paramilitary forces, and so did not interfere with the discharge, my lord, on that ground. Now, some of them, my lord, they went on appeal to division bench. Now, division bench remanded back the matter. Now, the only issue was, my lord, that in Assam Rifle Act, there are some provision for carrying out determination of low medical category. So the division bench said that, or single bench on remand said that the procedure under Rule 26 has to be followed. You cannot take recourse to CCS rules 56J, my lord. If I may just take your lordship to that particular order, my lord. That order starts from page 127, my lord. It's quite long history in this case.
It's quite long, it won't be from his bench.
No, not this order, but the history of the case. But page 130, if I may take your lordship.
Yes.
Now, I'll just read few paragraphs. At this juncture, it would be proper to bring out the exact extract of Rule 48(1)(b) of the CCS rules, as well as FR 56J, to enable to understand the stand taken by the respondent authority on the action taken against the petitioner, compelling them to retire prematurely. Retirement on completion of 30 years qualifying service. At any time after a government servant has completed 30 years qualifying service, he may be required by the appointing authority to retire in the public interest. 56J says, my lord, notwithstanding anything contained in this rule, the appropriate authority shall, if it is opinion that it is in the public interest to do so, have the absolute right to retire any government servant by giving a notice of not less than 3 months in writing so and so, so and so. And clause 2, in any other case after he attained the age of 55 years. So this was some kind of a service review just to weed out the deadwoods, my lord. Now, in Assam Rifle Para 10, you will see there is a specific provision to deal with this kind of situation. Retirement or discharge of subordinate officers and enrolled on grounds of physical unfitness. So the view taken by this honorable court was that, my lord, we cannot take recourse to 48 and this, we have to take recourse to 26 in future cases.
That's fine.
So now, my lord, thereafter he approached, because he did not file the appeal, my lord. So his case is that of attaining finality. Then he came before this on page 154, lords, you can see, my lord.
Yes.
So here the issue was, my lord, when he was discharged in 2015, when they approached this honorable court, my lord, Justice Sen at that point of time granted a stay, my lord, on the discharge.
Who's going to stay?
This honorable court, Justice Sen passed an order of stay in all those cases, my lord. So on the strength of the stay order, they continued for maybe 6 months or 8 months till the matter was disposed of. So so relief granted in this writ petition was that he should be paid for the period during the stay
was operating.
Stay was operating and when he served. So that has been done to him. That has been complied with, my lord. Now again he has come before this honorable court asking for lump sum compensation on the strength of.
Oh, is the third time he's come?
Third time, my lord.
Oh, habitually you're trying a lot.
My lord, this matter was heard at length, my lord, earlier, and they took some time to place some decisions on this, my lord. Your lord, so kindly, previous orders.
Oh, that's it. Now you come with another prayer.
Yes, lordship.
So even this matter was heard earlier, my lord.
Which matter?
Mr. Upadhyay argued this matter.
Yes.
You have authorities?
Yes, lordship.
What authority you have? That's only, it's just for the information, I mean the knowledge of the court regarding this definition LMC and whether it can become a disability. Then it'll be much easier to to distinguish these cases.
No, but I was just trying to point
other
out.
cases are there like medical hypertension, so whether it'll be disability or not. The disability pensions are a different thing altogether.
Now, my lord, page 122. Yes, other reports, my lord.
Yes.
Now, after those 100 cases were decided by this honorable court, my lord, after division bench remanded back, then Justice Ding to pass the order, saying that they have to follow Rule 26 and not 48 under CCS rules. A policy instruction have been issued by the government. Page 124 is the typed copy, my lord. Is issued on 6 September 2021. I read this entire document, my lord.
Yes.
Assam Rifles has been following the policy of retiring its personnel on completion of 30 years of service in accordance with Rule 48 of CCS pension rules. The said rule provides that any government servant who has completed 30 years of qualifying service may retire from service, or he may be retired by appointing authority in public interest under the service review boards. The Assam Rifles personnel are retired mainly on the ground of either medical LMC category or ACR criteria. Multiple litigations are being filed by such persons who are retired under Rule 48. More often than not, the department is not able to justify the public interest in such cases. With respect to the persons who are retired from service under Rule 48 on medical grounds, recently the Guwahati High Court allowed the writ petitions by common judgment order dated 12/2/21. The main contention of the petitioner was that the action of the authority in retiring the petitioner on ground of LMC by applying Rule 48 is not proper. The argument advanced in opposition was that members of armed forces would be in the medical category Shape 1, and if they are not in such case, their premature retirement would be in public interest. The court, after hearing the rival contention, observed agenda. Relying upon order dated 15/6/2016 in Sunil Kumar Sahi versus Union of India 3 others, which was upheld by the division bench as well as Supreme Court, the court held that the respondent should have followed the appropriate procedure under Rule 46 of the Assam Rifle Rules 2010. Decision to prematurely retire a government servant must strictly be in public interest, not be in an arbitrary decision or decision based on collateral ground. The appointment authority should record in the file that it has formed its opinion that it is necessary to retire a government servant in public interest. The rules relating to premature retirement should not be used to retire a government servant on grounds of specific acts of misconduct as a shortcut to initiating formal disciplinary proceedings or as a measure to reduction of surplus staff without following the rules and restrictions relating to retrenchment. Whether a case is covered by FR 56J or Rule 48 of the CCS pension rules or Rule 26 of the Assam Rifle, a detailed procedure is prescribed if such authority desires to prematurely retire a government servant. The basic consideration in identifying whether an employee is fit, competent to continue in the post and which he is holding would require that the entire service records of the government servant should be considered at the time of service for the purpose of forming an opinion as to whether government servant should be retired in public interest. The respondents have a duty to make an opinion regarding the integrity of
So
the
his LMC thing was under 26?
No, my lord. It was under 48J.
Under 48?
Yes, my lord. Now that has attained finality, my lord. Because he did not file an appeal before the division bench, my lord, when the matter was remanded back also. And this policy, my lord, if I may just take...
Yes, MS Tandem, how are you seeking to maintain it now? You retired when? When we retired?
2015, my lord.
Then?
But lordship,
was the
similar
decision filed?
personnel who were together with me in the writ appeals, the others, appellants, some of them, they received this lump sum compensation.
Where's that?
There's nothing, there's not on record.
That's not on record.
It's not on record, my lord.
Bring it, we'll see. Otherwise, it's very clear now, 26 has to be followed. That's why you have to make policy is very important, but Assam Rifle is let's for further hearing after 1 week, yes. MS is them to provide further materials with regard to the grant of disability pension to others similarly situated.
Yes.
Yes, if I
retired personnel. You have made a submission, you have to substantiate.
If any.
Yes.
31 and 32 similar
similar
matter.
matters, yeah.
But item 31 and 32, the petitioner is approaching this court for lump sum compensation for the first time.
We'll have it done together after next date. I'm short of words secretaries also. Yes.
36.
Yes, why did
my lord,
Mr. Rehman not allow adjournment this
my lord,
morning?
because the only issue remain here is the interest part, my lord.
Then where's the other people not having any interest in the case now they've gone?
Our colony, my lord. Yes, because the interest, my lord was on the other day was agreed on that. Our colony informed them. With regard to the interest part, my lord, I would like to submit, my lord, two judgment, my lord, which I got, my lord. 2003. Yes, 2003.
You have not given me.
No, even
6%.
My lord, in other in judgment, recent judgment also, my lord, 9%, my lord. With regard to this 2003, my lord, and another judgment is 2014, my lord. Two judgment only I am relying, my lord. In 2003, volume 3 SCC, page 14, para 9, my lord. Kindly have para 9. May I read, my lord?
Which department is this? The teachers?
My lord, no, with regard to the employees, my lord. Not
My lord,
to
they were
the-
it looked like they were suspended from service and subsequently they were taken to service and that was counted.
No.
This, my case is different, my lord.
My lord, the only the issue here is, my lord, there's an statutory provision under Gratuity Payment of Gratuity Act, my lord. Under section 7, my lord, clause 3 and 3A, my lord. That
So if they paid your gratuity, that means there's not a case of they say not entitled to it. You're entitled to it. They're entitled to interest also.
My lord, we have never said that they are not entitled.
Then they
My
have
lord,
to
so
pay
far as
interest on
the
late payment.
delay, my
That's
lord,
the right.
there was no delay, my lord. The matter was under process. It was under process. And
How
my
long
lord,
is the delay?
My lord, the petitioner herein, my lord, were retired in 2019, and after that, my lord, the 3.5 lakh were released. Then, my lord, after the fifth pay commission, my lord, the recommended to the government for enhancement of the gratuity amount from DCRZ 3.5 lakh to 10 lakh, my lord. Then, my lord, the amount was increased. My lord. The state government has accepted, my lord, from 3.5
when
lakh to
it was enhanced, you only pay 3.5 lakhs. You take interest on 3.5 only 6%.
my lord,
yes, my lord, the remaining amount, I am not claiming
Remaining amount you're
3.5.
not entitled to.
No, my lord, the remaining amount which I already received prior, after the retirement, 3.5 lakh, I am not claiming on that. This writ petition is claiming for releasing of the gratuity amount of 6.5 lakh, my lord. On that, I am claiming the interest part. Because, my lord, kindly have the...
Now the 6.5 has been paid to you also.
Recently, my lord.
my lord,
After
this is not
When was the
actually...
enhancement done?
My lord, the enhancement process started in 2024, my lord. And then, my lord, when the entire thing was being examined, my lord, there was no proper calculation from which period to which period this was supposed to be calculated. It was going on, my lord.
That cannot be the excuse, my lord. My lord,
Very much, my lord. It involves a huge around, my lord. As per as my information, there were around more than 500 employees who were entitled for enhancement.
It's not a bounty, my lord. It's a property right, which is...
No. Property right fine if all the conditions are satisfied.
Yes,
suppose they have sanctioned, they have factored in that your due gratuity of 1 lakh. Okay, suppose they delay in payment of gratuity, you're supposed to get after retirement. They delay for 2-3 years or 1 year. Then in that instance, there's no other confusion. Then you'll be given whatever percentage, 6 or 9%, whatever, on the delayed payment. Now in this case, what this MS Colony is submitting is that 3.5 was given to you initially.
My lord, yes.
Then there was an enhancement after how many years?
My lord, enhancement, my lord. My lord, the entire process so far, because my lord, the affidavit which I have filed is only in the context of the amount which have been released. I have not filed an affidavit in opposition, and this has come after I have filed an affidavit. And my lord, what I would like to submit here is that the entire case is not about about DCRG. It is an enhancement amount which was decided in the year 2024. And then, my lord, there was no clarity within the department to which extent it should be paid to all the employees. So it was being examined.
Then in that case, my lord, kindly I request my learned friend to bring records with regard to from which date the remaining 6.5 were accepted by the state government. Because
when was accepted?
My lord,
that's what the school is looking for right now.
Yes, my lord. I've just now received one from my client, one letter, white letter. It is 16/7. Though I don't have in my WhatsApp. I just received it yesterday night. 16/7/2024. A special officer to the government of Meghalaya Education Department issued to the director of school education, informing that enhancement of gratuity amount from 3.5 lakh to 10 lakh, my lord.
Accepted.
My lord, the content of the letter is enhancement.
My lord, I'm not aware of
thereafter, my lord.
Get the order when it was implemented.
Yes, my lord. Exactly. Which date the 6.5 is accepted?
Yes, this is the matter.
Admitted, my lord.
In the course of hearing, this seen that further details are required with regard to the date of enhancement of the DCRG, which was paid to the petitioner. So Ms. Arkunni prays for 2 weeks' time to obtain the necessary instructions.
My lord.
Yes. After 2 weeks.
Deeply obliged.
37 to?
My lord, 39. 36 to 39.
39, my lord. 4 items.
4 items.
Which one? Okay. Yes.
Deeply obliged.
May it please your lordship, the conducting counsel who is appearing through BC is on lex before Delhi High Court. So
Just after 1 week, yes, the day or something.